Hello viewers, let us discuss today the topic Social Welfare Policies and the State in India. In today's lecture, we'll try to analyze and examine the nature of social welfare policies pursued by the Indian state since independence. We know that the Indian state is a welfare state. But we also need to know how the concept of social welfare emerged and how it has been formulated and implemented. In order to facilitate better understanding of this topic, the entire lecture has been divided into 4 core areas. We will start off by understanding the concept of social welfare. Then we'll try to understand the various approaches to social welfare, most importantly, the residual and the institutional approaches. Thereafter, we'll try to understand the specific welfare provisions contained in the Indian Constitution. In the last segment, we would move on to the specific welfare provisions provided by the Indian Constitution and formulated by the Indian government from time to time for the scheduled castes, scheduled tribes, women, disabled persons, as well as for children. Let us start with why did the concept of social welfare emerge in the modern industrialized world. Now, the concept of social welfare is related to social problems associated with industrialized societies. Now, we need to understand that poverty, sickness, unemployment, social disorganization are not new. They have been a part of the growth and evolution of society, but these problems became so acute in the late 19th and early 20th centuries that the modern state had to interrupt and provide for certain welfare provisions to ameliorate the condition of the different segments of the population. Thus, welfare emerged in order to address different societal problems. Let us now start with a definition of social welfare. Now, social welfare refers to the organized provisions and services to the society to deal with social problems. According to Encyclopedia Britannica, social welfare is a system of laws and institutions with which a government attempts to protect and promote the economic and social welfare of its citizens, usually based on various forms of social insurance against unemployment, accident, illness, and old age. Thus, the purpose of social welfare is to assist individuals in their times of need. Based on this understanding of social welfare, let us now try to understand the various approaches to social welfare. Because students, the concept of social welfare and the implementation of social welfare policies are not uniform in different parts of the world. Some countries have to provide for more social welfare provisions, while others can leave it to the market to address the societal concerns. Now, there are 2 major approaches to studying social welfare. First is the residual approach and the second one is the institutional approach. The residual approach provides for the fact that every individual has access to 2 natural channels through which they can fulfill all their needs. Now, these 2 natural channels are the family and the market economy. However, these 2 institutions sometimes do not perform properly or they are not in an adequate position to fulfill the needs of the individuals. For example, sometimes family life is disrupted, depression, or sometimes the individual himself cannot make use of these channels. In such cases, a third channel is required to fulfill the needs of social welfare. This third channel is the state. So the residual approach focuses and emphasizes on the fact that social welfare provision is a crisis management program and it comes in only when the market economy and the family fails to provide the necessary requirements of daily living. So this is a crisis mechanism. Social welfare is not a uniform or daily requirement. The state will step in to provide for welfare provisions only when the other two institutions fail to provide the needs of the individual. Thus, the residual approach says that welfare is a residual requirement only when there is a crisis in society which prevents the family and the market from fulfilling their necessary functions. Now, the institutional approach focuses on a different aspect of state welfare. The institutional approach focuses on the role of the state as an institution in fulfilling the welfare needs of the individuals. Thus, this approach focuses on the fact that state welfare is a necessary ongoing function of a complex interdependent society, and it is a normal social institution to help realize their necessary requirements. More so, it is the state which is responsible for optimum allocation of resources in society. Thus, this approach disavows the notion that social welfare is a primary crisis service. According to the institutional approach, social welfare is a necessary function of states across the world, and therefore it is pertinent on the part of the states to provide for different forms of social insurance and social security in order to protect and promote individual interests. Now let us try to understand the concept of welfare state. We also know that all states around the world may not be welfare states. A welfare state implies a concept of government where the state plays the primary role in the protection and promotion of economic well-being of the citizens. Thus, the state is very proactive in providing for special provisions for catering to the needs of the marginalized segments of the society. It is based on the principles of equality of opportunity, equitable distribution of resources, and responsibility for those who are unable to avail themselves of the minimal provisions of good life. The great political scientist T.H. Marshall identifies the welfare state as a distinct combination of democracy, welfare, and capitalism. He is of the view that state welfare can function properly within a democratic environment. Interest in welfare emerged along the 19th century as industrialization created a sphere of urban poverty and social division that in different ways distributed conservative, liberal, and socialist politicians. But all of them have come to accept the fact that irrespective of the type of countries, whether they are capitalist or socialist, state welfare should be a part of government functioning. Now let us try to understand the history of social welfare. Germany is generally held to be the first country in the world to introduce the concept of social welfare through social insurance. In fact, Bismarck introduced for the first time a nationwide system of social insurance which was previously unheard of. The Russian Revolution of 1917 led to the abolition of private property and institutionalized the ascendancy of the state through central planning and brought in the notion of state as the provider of different kinds of social services. Thus, the Russian state after 1917 focused on welfare as an important part of state functioning. The USA did not have any organized welfare system until the Great Depression, but thereafter, President Roosevelt introduced a scheme of measures in order to provide for different types of welfare provisions to different segments of the society. In the subsequent years, we find that America embarking upon a path of social welfare. Like USA, UK also did not have an organized welfare state provision until we find the concept of state welfare was introduced in 1911 by Prime Minister David Lloyd George, who introduced the National Insurance Scheme, which was later on developed and improved by Prime Minister Clement Attlee. Thereafter, we find in UK, Britain developing a slew of comprehensive social security measures to provide subsistence income in cases of individuals suffering from sickness, old age, disability, or people who were unemployed. Thus, we find European countries embarked upon a strategy of social welfare in the later half of the 19th and early 20th century. Let us now come to India. When did India start its journey of being a welfare state? It was after the attainment of independence that social welfare became an important part of discussion in the Constituent Assembly, debates leading to the introduction of a separate section, we call it Part 4 in the Constitution, titled Directive Principles of State Policy. Now we need to understand that after independence, Indian state transformed itself into a completely welfare state given the range of problems that India was encountering with the advent of independence. Fathers of the Constitution appreciated the greater role of the state in formulating and implementing various social welfare schemes for different segments of the population. The basic aims of the welfare state has been encapsulated in Part 4, titled Directive Principles of State Policy. But this is not to say that only Part 4 of the Indian Constitution provides for state welfare. State welfare is enumerated in other different segments of the Indian Constitution in the chapter on fundamental rights, in the part on fundamental duties, as well as various provisions relating to the scheduled caste, scheduled tribes, women, children, as well as the different segments of the society. Let us now try to understand what are the different provisions contained in the Constitution which provides for a series of measures to be introduced by the state in the years to come. Now, we find that social welfare provisions have been categorized for different segments. It can be educationally and socially backward class of citizens, it can be women and children, it can be scheduled tribes, scheduled caste, and it can be in terms of the different marginalized segments of the population. To give you a summarized version of the different constitutional provisions, let us take a snapshot into the specific provisions contained in the Constitution. We start with Article 15, which provides for absence of discrimination on the basis of caste, class, sex, gender, and so on and so forth. However, 15 Clause 4 specifically provides for special provisions for the advancement of socially and educationally backward class of citizens or for the scheduled caste and scheduled tribes. Thus, 15 Clause 4 provides for specific welfare provisions to be made for the marginalized segments. Article 16 provides for equality of opportunity in matters of public employment. Under Article 38, which is a part of the segment on directive principles of state policy, it provides that the state is directed to secure a social order for the promotion of welfare of the people. Thus, the concept of welfare is clearly incorporated in the Constitution. Article 39 provides that the state shall secure to its citizens that they have the right to an adequate means of livelihood. Article 41 provides for right to work, to education and to public assistance in certain cases. Article 42 directs the state to make provisions for securing just and humane conditions of work and maternity relief. Article 46 promotes the educational and economic interests of the scheduled caste, scheduled tribes, and other weaker sections of society. Article 47 provides that it is the duty of the state to raise the level of nutrition and standard of living and to improve public health. Let us now try to understand the specific provisions for the scheduled caste, scheduled tribes, children, women, as well as persons with disabilities. Let us start off with the specific provisions contained in the Constitution as well as the laws passed by the Parliament to cater to the needs of the scheduled castes. The main safeguards provided in the Constitution for the protection of interest of the scheduled castes are the abolition of untouchability and the forbidding of any practice in such form contained in Article 17 of the Constitution, the promotion of their educational and economic interest and the protection from social justice and all forms of exploitation contained in Article 46, the removal of any disability liability restriction with regard to access to shops, public restaurants, hotels and places of public entertainment, or the use of wells, tanks, bathing ghats, roads and places of public resort, maintained wholly or partially out of state funds or dedicated to the use of general public, and special representation of the scheduled caste in the Lok Sabha as well as the Vidhan Sabha is contained in the Constitution. After the enactment of the 73rd and 74th Constitution and Amendment Act providing for rural and urban local self-governing institutions, seats have been reserved for scheduled caste and scheduled tribes in all local self-governing institutions. Now, in order to further promote the interests of the scheduled caste, the National Commission for Scheduled Castes have been created. The commission performs the following functions. It investigates and monitors all matters relating to the safeguards provided for the scheduled caste under the Constitution. It inquires into specific complaints with respect to deprivation of rights and safeguards of the scheduled castes. It participates and advises the government in terms of socio-economic development of the scheduled caste, and it has been empowered to discharge such other powers and functions as may be necessary to further the cause of the scheduled castes. There was another commission which has been created in 1994. It is called the National Commission for Safai Karmcharis. The main function is to recommend to the central government specific programs for the elimination of the inequalities in status, facilities and opportunities for Safai Karmcharis through a time-bound program. It is empowered to investigate special grievances and matters relating to implementation of programs and schemes for the welfare of manual scavengers. The Commission is consulted on major policy matters affecting Safai Karmcharis who suffer social humiliation and human atrocities. Let us now try to understand the specific programs for scheduled tribes. The Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006 is considered to be a landmark legislation in the protection of the rights of the tribal communities or Adivasis in India. This act is also popularly called the Forest Rights Act. The law concerns the rights of forest-dwelling communities to land and other resources denied to them over decades as a result of the continuation of the colonial forest laws in India. The National Commission for Scheduled Tribes is an constitutional body which has been created in 2002 in order to further and promote the rights and interests of the scheduled tribes in India. The Commission investigates and monitors all matters relating to the safeguards provided in the Constitution and any other law which is in force at the time of the continuation of the practice. In order to facilitate better tribal administration, the Constitution provides for two schedules. Schedule 5 or 5th schedule and the 6th schedule provides for specific tribal administration provisions. According to the 5th schedule, it applies to administration and control of the scheduled areas and scheduled tribes in any states other than the 4 northeastern states of Assam, Meghalaya, Tripura and Mizoram. What is very interesting to note is that the 5th schedule provides for specific provisions for tribal governance and autonomy for tribal communities to establish district councils in order to administer the tribal areas. Like the 5th schedule, the 6th schedule also provides for provisions for tribal governance, but the 6th schedule is applicable to the northeastern tribal dominated states. The 6th schedule seeks to provide for tribal district councils or autonomous councils which have been entrusted with executive and legislative powers in order to fulfill the aspirations of the tribal communities to regional and tribal autonomy. In pursuance of the 6th schedule, a number of autonomous councils have been created, such as the Bodoland Territorial Council or the Tripura Tribal Autonomous Development Council, which has been functioning for the last few years, which has strengthened the cause of tribal autonomy. Let us now move on to the specific welfare provisions for the women in the country. Article 15(3) of the Constitution provides for special provisions for women and children in the country. Article 39A of the Constitution, which is a part of the directive principles of state policy, urges the state to provide equal right to adequate means of livelihood for men and women. Article 39D provides for equal pay for equal work for both men and women. Article 42 directs the state to make provision for securing just and humane conditions of work and maternity relief. Article 51A(e) enjoins upon every citizen to renounce practices derogatory to the dignity of women. Article 243D provides that 1/3 of seats in panchayats shall be reserved for women. In addition to these constitutional provisions, the Indian Parliament from time to time has passed a number of legislations to promote and protect the interest of women. Some of them may be outlined as follows. We have the Immoral Traffic Prevention Act 1956, the Dowry Prohibition Act 1961, amended in 1986, the Commission of Sati Prevention Act 1987, Protection of Women from Domestic Violence Act 2005, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, Criminal Law Amendment Act 2013. In addition to this, the National Commission for Women was set up in 1992 to deal with the various problems faced by women as well as help them in the process of women's empowerment. The main task of the Commission is to study and monitor all matters related to the constitutional and legal safeguards provided to women and to review the existing legislations, suggest amendments where necessary. The Commission also ensures speedy redressal of the grievances of women. This is not all. The Ministry of Women and Child Development have been created to be the nodal agency for implementation and coordination of all programs related to women's welfare and development. The ministry has over the years implemented a number of welfare provisions for women. In the next section, we'll try to understand what are the welfare provisions that have been forwarded by the state for persons with disabilities. The government has enacted 4 major legislations for persons with disabilities. Persons with Disability Equal Opportunities, Protection of Rights and Full Participation Act 1995, which provides for education, employment, creation of barrier-free environment, social security, etc. The National Trust for Welfare of Persons with Autism, Cerebral Palsy, Mental Retardation and Multiple Disabilities Act has provisions for legal guardianship of the 4 categories and creation of enabling environment for as much independence to them as possible. The Rehabilitation Council of India Act 1992 deals with the development of manpower for providing rehabilitation services. The most important legislation so far made is the Rights of Persons with Disabilities Act 2016, which provides that the appropriate government shall ensure that the persons with disabilities enjoy the right to equality, a life with dignity, and respect for his or her own integrity equally with others. The government has to take steps to utilize the capacity of the persons with disabilities by providing an appropriate environment. The national policy for persons with disabilities was pronounced in 2006, which is also considered to be a landmark policy for persons with disabilities. The national policy recognizes that persons with disabilities are valuable resources for the country and seeks to create an environment that provides them equal opportunities, protection of their rights, and full participation in society. The national policy further provides that prevention of disabilities and rehabilitation measures and economic rehabilitation is of utmost necessary for ensuring that they become a part of mainstream society. Let us now quickly go through the welfare provisions that have been provided in our Constitution and through legislations for children. The Constitution of India provides a plethora of rights for children. For example, right to equality is provided in Article 14 of the Constitution. Article 15, Clause 3 provides for special provisions for women and children. It also provides for the right to education. The Constitution also provides to right to education for children via Article 21A of the Constitution. Apart from this, Articles 23 and 24 protect children from various forms of exploitation and beggary. In fact, not only the fundamental rights segment, the directive principles also have some pronounced principles to protect children from being subjected to inhuman labor. For example, Article 39 provides that the state shall in particular directs its policy towards securing the health and strength of the workers, men and women specifically, and the tender age of children shall not be abused, and that citizens are not forced by economic necessity to enter avocations unsuitable for their age or strength. Apart from this, the Constitution also provides that children should be given a suitable environment for their holistic development. Note this, Article 51A(k) provides a duty upon the parents to ensure that the children go to school and are not employed below 14 years. The Constitution also provides for a responsibility upon the state to ensure that early childhood care and education is provided to all children in the country. Now, in order to further promote and protect the rights of children, the Protection of Child Rights Act provided for the establishment of a Commission for Protection of Child Rights. Accordingly, the National Commission for Protection of Child Rights came into effect in the year 2007. The Commission deals with all matters relating to the protection and promotion of the rights of children in the country. The Commission is also empowered to ensure effective implementation of laws relating to children. As envisaged in the Commission for Protection of Child Rights Act 2005, the National Commission for Protection of Child Rights have been created in the year 2007. The Commission has been entrusted with the task of promoting and ensuring protection of rights of children. It is also entrusted with the task of effective implementation of various legislations related to children. Let us now quickly summarize what have we studied in today's discussion. The development of social welfare in India have been phenomenal. The setting up of the Ministry of Social Justice and Empowerment, Ministry of Women and Child Development, Ministry of Tribal Affairs as full-fledged ministries, as well as the establishment of the National Commission for Scheduled Castes, Scheduled Tribes, National Commission for Women, National Commission for Minorities constitute great landmark in the journey towards effective social welfare legislation. However, we have to go a long way in completely ameliorating the plight of the marginalized and underprivileged segment of the society. State welfare has to be reconceptualized and tailored in order to ensure that different segments of the community have their rights and obligations fulfilled with the help of the central and the state governments. Thank you.